Thank you, Dr. Machado. I also want to thank the FMA and the FMA staff for allowing me to visit with you and speak to you tonight. I also want to thank you for taking time, because I know how valuable your time is. I want to take a moment to introduce one of my colleagues in this, who's also on our board and been helping me in this process, Dr. Jeff Siegel, and he'll be a part of the Q&A here in a second. He's a neurosurgeon and an attorney. I guess he has to go to a psychiatrist to do that as well. But anyway, he's going to be here. We didn't know if he was going to be here or not, but he's going to be here to answer questions later and so forth. And so I wanted to go ahead and introduce him now before we get started. What I'm here to talk to you about is how to replace, not reform, malpractice tort, but how to replace it with an administrative compensation system. First of all, a little bit about the background. You heard a little bit about it, but I wanted to let you understand. Now, if you're a doctor over 50, you may have heard of a company called Jackson & Coker that I started in 1978. So I've been in a physician advocate. I'm not pandering to you, but I've been a physician advocate and partners with many doctors and over the years and so forth. And so I have owned insurance companies. I have owned surgery centers, a couple of small hospitals, you know, and many facets of healthcare. I say that not to brag or anything like that, but I feel like I have a unique perspective and experience level to really understand how healthcare works, and so I bring that to the table. How do we get started on this? It was interesting. About 4 years ago, last month, we did a survey to all of our physicians, or to our physician database, to ask them, did they like Obama's plan, did they like Clinton's plan, or McCain's plan, and what did they like, dislike, so forth. And one unsolicited, loud comment was, it didn't address malpractice in defensive medicine. Well, I've been in healthcare for a long time, and I was wondering what that meant. My experience is that physicians don't major on minor, especially when it's a collective voice like that. So, so 2 or 3 years later, I wanted to go back and find out what the issue was with defensive medicine, and so we did a survey in 2009, right before the ACA was passed in December, to find out more about defensive medicine. And one of the questions we asked was, what percent of overall healthcare cost is related to defensive medicine? I was shocked to find out that 3,200 physicians said over 34%. Now, our definition at that time was very stringent. It said, test only for the purpose to avoid a lawsuit. Totally unnecessary. I was shocked for a couple of reasons. I didn't know it was that much. And so I knew nobody knew who Jackson Healthcare was, but I knew that we had a problem that we needed to start talking about and having a conversation. So in January 2010, we hired Gallup to do a survey and do the same thing on a scientific basis, on a polling basis, and they came up with 26%, which was still a very significant number. And so we went to the Washington Press Club the Monday before, Thursday before people, the Democrats and Republicans got with the president that Thursday and so forth. But here's what I also found out. The states like Texas that had some of the best tort reform, doctors practiced as much, if not more, than the national average of defensive medicine. And the prevailing solution at that time was that caps and some of these other things would work. And so I was intrigued by that. And so I wanted to go and study it further, and that's where we start tonight. So first of all, let's talk about the goals of the current tort system. It's basically deterrence of unsafe practices, compensation for injured persons, and corrective justice. It just doesn't work. This is a lady that wrote her term paper as a lawyer in the Annals of Healthcare, and she won this in the Healthcare Law Review, and it was very crisp. In fact, one of her solutions we didn't know was a no-fault system, and that's why she was talking about it. First of all, there are 3 problems in the current system, 3 overall problems. Number 1, it promotes defensive medicine, as you guys know. And in Florida, that's 34%. This year, we validated on a polling of Florida physicians, 34% are potentially $43 billion per year. It prevents access to justice. And what we mean is less than 20% of medically injured patients actually receive compensation, mostly low dollar value compensation, and we'll go into this in more detail. And then it's a hurdle for patient safety. I mean, it's very difficult in a blame and shame system to really improve from a patient safety standpoint. We'll talk about that. But these are three material problems with the current system that we all live under at this point in time. So again, Gallup came out with the 26% of how much defensive medicine won. That's $650 billion a year. It's about 2,000 a person. In Florida, again, it was 34%, about $43 billion. So then what I wanted to focus on is a lot of people, when they talk about malpractice and costs and so forth, they focus on what I call the tip of the iceberg. The traditional tort reform, caps, and some of these others, disclosure and apology, settlement, mediation, and so forth like that, focuses on what we think is the tip. And we have identified that actuarially as $31 billion in 2010, 2011. $31 billion just on malpractice costs alone. What we're focusing on is the iceberg, the $650 billion nationally that doctors are saying they think is related to defensive medicine. And so that's what we're trying to focus on, is not the tip. So we care, but we're not focused on necessarily bringing down malpractice. We're really trying to get to the root cause, and that's the defensive medicine, which is so expensive. And by the way, again, none of the tort none of the tort states had any difference from the studies that we had. This is unique to the United States. We polled the same Gallup questions in Canada, UK, Sweden, New Zealand, and we were going in a couple of other countries, and we just decided to quit. They didn't even know what that meant, the words meant, defensive medicine, so they obviously came in zeros. And we believe that one reason is doctors in the United States are the only ones that are personally financially liable for their professional mistakes. Personally financial, all your assets are on the line unless you're Bayer or do some other things like you do in Florida. And they're the only ones practicing defensive medicine. So this is totally unique to the United States in that environment. So the first thing I wanted to do, you guys focus on every day in your practice in dealing, not in treating symptoms, but the problem. So I wanted to understand, if CAPS did not solve the problem and some of these others, then what's the problem? What problem are we trying to solve? And we went back out to the physicians, got another 3,000, and asked a whole bunch of questions about this. And it boils down to two things. Number one, there's obviously a personal financial exposure from these jackpot awards that physicians are concerned about. Just as important, what we learned, though, is physicians abhor defending lawsuits. I mean, we had an ER doctor that told us that I would, scan patients till they glow in order to avoid a lawsuit. It is amazing to what extent you just don't even want to get involved. And it's just, and those are the two main problems that we teased out. And if your solution doesn't solve those two, it is my opinion, and 70% of doctors that we've surveyed opinion, that defensive medicine will not decrease unless you get rid of the shame and blame litigation system. And so those are the problems. And so therefore, so what's the solution? Well, first of all, let's talk about why defensive medicine harms patients. First of all, obviously unnecessary tests and procedures. High-risk patients are sometimes denied coverage. Physicians can't afford to admit mistakes. There's obviously increased health care. Sometimes slow to adapt to saving technologies. I put the first MRI, freestanding MRI in Atlanta, I think it was around 1980 if my memory serves me right. And I can't imagine putting the first MRI in this environment that we're in today and even hoping to get reimbursed or doing some of the other things. And so because of all the risks that entails at that time. Patients also lose in the litigation system from other ways. It drives a wedge between the patient and the physician. It denies access to justice. A lot of people don't have access, and we'll talk about that. Less than 5% of the cases that are filed go to jury. Patients receive less than 50% of the awards when they get it. And then it takes 3 to 5 years to get the money anyway, and I can tell you that it's mostly 4 to 5 years from our actuarial study. And patients don't like the stress of litigation either. And most of you know that elderly people just will sometimes just not file a lawsuit even if they had a slam dunk. They just don't want to get involved with that. So it's not something that's just one-sided that people don't like. It's ineffective for patients. Let's talk about the facts from last year. Let me go through a claims, let me just give you some data here. Last year there were 9,000 closed claims. Now this database is of all malpractice carriers that represent physicians. It does not include self-insured and some of those others. I have that data, but this is the best data that I thought would be interesting for tonight. 73% of those are dismissed without payment. The rest of it, there are payments. There's only 8% that actually go to a jury trial. The doctors win 7.9% of that time. So jury awards to patients are only 51 last year out of 9,000. So when you look at the rest of the story, here's what you're doing. You're paying $8 billion a year so that patients can receive $1.4 billion just for the purpose of 51 people getting a jury award last year, averaging $725,000. You could not design a more inefficient way to get patients compensation than the system that we have. But that's what we have. That's the data that we have from last year. So the solution that we believe is create the patient's compensation system that is modeled constitutionally after the workers' compensation system. But listen here, it's operationally different, and we'll talk about that because I understand it is not operationally like workers' comp. It is legally based on that for constitutional purposes. So let's talk about how a little bit about workers' comp, because most people may or may not know this. Workers' comp laws started in 1910, and it went on a state-by-state basis. It was, at the time, employees were hesitant to sue their employer because they're afraid they'll get fired or their family would get fired. Employers that were afraid that if somebody cut off their leg, their whole business and their whole net worth would go away. And so the workers' comp system was created in every state in the United States, eventually within a 2 to 5 year period. And the grand bargain was a bargain to say, you give up your right to sue your employer. You cannot sue your employer for the guaranteed right for compensation if you're injured. And this protected the employers, and no longer were employees afraid to file claims and so forth. And it was upheld in every state constitution, Supreme Court, and in the U.S. Supreme Court. It was upheld as constitutional at that time. And so that was the problem they were trying to solve. So let's talk about how does patient compensation work. First of all, you enter the system through a patient advocate. A patient can file a claim, call in, and so forth, and there's a patient advocate that is designed to basically help them navigate through the system. Then it goes to a medical review department, and let me talk to you about what that is. And that is called the Legally Office of the Medical Review in the bill. When you read it later, we'll hand it out. But basically, it is headed by a physician. It is a chief medical officer. And their job is to focus on getting all the information, the clinical information, interviewing all the people, and then creating a file for an expert panel outside to make a decision. And their job is to appoint the appropriate experts, independent, non-employees of patient compensation system to make a decision. And let's talk about, so the first thing I want to tell you, that no employee of patient compensation system, the way we drafted the bill, can make a decision of whether it was medical injury or not. It is someone not employed that may be given a stipend to consult to decide whether or not it was, and it's a 3 to 5 person panel, and we'll talk about that. First of all, these are pre-approved physicians and other medical experts, and that is already pre-approved. We would hope that is be far and wide, that as many specialties, practicing physicians and so forth, that people feel comfortable with. There would be 3 physicians appointed if there's only a physician involved. If there's a system like a hospital or nursing or something like that, there would be 5, 3 physicians and 2 other experts, maybe a nurse, physical therapist or hospital administrator or something like that. So it would be physician controlled and slanted from that standpoint. All the identifiers of the patient record will be provided and redacted. And you cannot know, the chief medical officer cannot choose somebody that might even know about what the case is, and so they would never choose somebody that went to the same hospital for the same area and so forth. But in addition to that, the file is redacted. There's no identifiers of the record. Once that's done, the simple question is yes or no, was it a medical injury? And that panel makes that ruling. If it's yes, then it goes to a compensation department. And the compensation department has two jobs. Number one, before all this gets started, they create a compensation schedule based under current and historical awards in the past in our current system. For the last 25 years, there's a historical awards of how much for types of severity of injuries and so forth. And the second is to award the compensation and write the check. From that standpoint, there's an administrative law judge, a part of the process, and there's this judge's job is to ensure that the process is applied in accordance to the law. And also, this is a limited appeal. You can't appeal because you don't like the decision. You can only appeal if, for instance, they didn't talk to all the nurses, they didn't talk to the right medical records or something like this. Both the doctor and the patient, if they want to, can be a part of that process to make sure all the elements came through. But once that's done correctly, and if an independent panel has the right experts and the people don't know anything about the case, as long as the process was done in accordance to the law, then there's no appeal other than that. You could also appeal based on their compensation. I mean, did they apply the compensation? But basically, the appeal is limited to process only. After that, it is a final ruling. You cannot go to another court and say, we don't like this and we want to sue. Again, if you're going to ever be in a litigious situation where your lawsuit is filed against you, then defensive medicine is not going to work. And so we feel like everybody must be in the system from that standpoint. Then there's a quality improvement department. The quality improvement department does not have any capability to tell anybody to do anything. Their job is to record all claims data confidentially and share lessons learned with providers. Jeff and I were talking to the Swedish system, and one of the advantages they have by having all this claims data, even when there's early signs of maybe it's not negligence or medical injury, but there may be some things that are happening that they can ward off. They tell them that. But he was sharing with us that they had a prosthetic problem that had 2 or 3 bad outcomes, and so immediately in 30 days they sent out to all orthopedists and said, hey, we're having problems with this, be on alert, be careful. In our system, we have no way of doing something like that. So that's their job, is to help from that standpoint, maybe give scientists other data and so forth like that to take a look at. So that's basically how the system would work, and I'm sure you'll have some questions that we'll talk about a little bit later. The source of funds, where's the money come from? Well, it's funded the same way that it is today. You know, physicians and medical professionals basically buy insurance either from an insurer or a patient trust fund. Now, this is up to each state to decide how to do this, but basically if you like your medical malpractice carrier, you can buy malpractice just like you do now. If you're self-insured, you can still be self-insured, however you do it now. Then that's paid. The patient compensation system determines if there's compensation, and the compensation pays the patient, and then that's basically the way the system works. So it's basically the same type of money flow that we have in our current tort system. We think it's a more efficient use of existing funds. Today, less than 20% of injured patients actually get compensation. They only get 17.5% of it. And it takes 3 to 5 years. Under our system, we believe it'll take less than maybe 180 days, and they get 80% of the cost that you're putting into the system by our actuarial studies. So we think it's more efficient use. The patient benefits are obvious. First of all complaints are reviewed. One of the things that's bad for both doctors and patients is really, it's basically access to a business transaction between 2 attorneys. That's what we have. There's never any indication that you were vindicated or the patient was wrong or the doctor's going to do better next time. There's no resolution, so nobody's actually heard and somebody calling balls and strikes, so to speak. So all patients' complaints are reviewed. They get their money faster. It reduces exposure to unnecessary tests. The guaranteed money, increased patient safety, access to justice that we talked about, and then more compensation to more patients. That's the benefits to them. Let's talk about the physician benefits. Hopefully they're obvious. Number one, there's no longer any personal financial risk. You could never have anybody come and take money from you once you've made your malpractice payment. You're done. Second, there are no lawsuits to defend. You're no longer being sued. They no longer have the right to sue you for any reason other than something like the Michael Jackson doctor, or something like that. Something is just completely off the wall. Does not assign blame. We're not assigning blame. When we first wrote the bill, we were going to go ahead and say, okay, you were wrong, whatever, report it and so forth. But what we learned from the Swedish system is that is really not good for patient safety, and that we need to eliminate any blame and shame part of the system, and so we no longer will assign blame. There's also a benefit later on that we'll talk about the National Practitioner Data Bank, and that it helps in that respect as well. You can practice without judgment by non-medical peers. I mean, one of the things I find that most physicians are just upset about is people that don't know anything about medicine make a decision. I'm asked by people that are non-healthcare, well, what about the fox guard and the hen house? The physicians are going to rule in favor for their buddies and all that kind of stuff. And I basically say, if somebody does something wrong in heart surgery, do you think you have the capability of making that decision whether they did something wrong? No, of course not. I don't either. So, and I believe that doctors will get this right. We've seen it in other areas, and Jeff can give you some examples as well. It's safe to admit mistakes. It may be a while before under the system before you could do that, but I think most people actually, some people do admit mistakes, but it's just better if you can say, I'm sorry, or being concerned, or whatever. The interesting thing about Sweden, it took a while, but I think up to about 50% of the claims are supported by the physicians. In other words, they would say, look, this was medical injury, I'll support you in your claim and so forth, and that kind of goes in a fast track. It still doesn't hurt them, but they're able to do that, and I think we'll have some of that as well. The claims are not reported to the National Practitioner Data Bank. Now, this is our opinion. It's a very strong opinion. It's not a guarantee. We have an opinion from an ex-general counsel of the Department of HHS. We're still wanting to get that validated. We don't fit any of the definitions of the National Practitioners Data Bank. For instance, in the bill, I've loosely said claims in here. Well, in the bill, you will notice, and we have a summary of the bill when we hand this out for you, that talks about some of the language in the rationale, and this is one of them. They file for an investigation, not a claim. There's no blame assigned of anybody doing wrong and so forth. So we don't fit any of the definitions. Kind of like NICA. NICA doesn't report to the data bank as well. So, we have rewritten the bill. One of the other things when we first drafted the bill, we basically said, look, we will just have the insurance company pay this patient over here $200,000 if that was the case. We now have all payments coming to PCS, and so the patient is paid on behalf of patient's compensation system, not on behalf of a doctor or anybody else. There was medical injury, they get paid. And so there are many things that we've done to put belt and suspenders. We strongly believe, our attorneys here believe strongly, that it will not be reported. Because one of the concerns is that there's a lot more claims and a lot more volume and so forth, that that you'd have more people to defend and so forth like that. And we wanted, we have a lot of problems with the National Practitioner Data Bank on multiple fronts, but we've done everything we can, and we believe we have a strong case that none of these would ever be reported. And malpractice premiums will not increase. Now, this is the biggest issue that I want to talk about. I'm going to go in a little bit more detail if you don't mind. Before I've talked to doctor groups and so forth and said malpractice won't go up, our actuary said it won't and so forth. And so I want to drill down on that and show you what the numbers are. And so what we've done is basically hired Aon Risk Solutions. We've had actually We've actually had 2 actuarial studies because we wanted to compare them and make sure that they're both in the same ballpark, and they were. Aon has 60,000 employees in 120 countries. They're the largest insurance brokerage in the world, and they're the largest actuary in the U.S. for self-insured hospitals. They don't represent a lot of medical malpractice carriers because, and we have actuarial studies from companies that represent medical malpractice carriers, and they felt like they were in a conflict of interest to give any of the details. And so we felt like the self-insured actuaries were the right ones, and so this is a result, a high-level result of their opinion. So, well, let's talk about, first of all, what are the elements of the cost of malpractice. When we talk about cost or payments, I want to bifurcate this a little bit. The premium cost is 100%. There are 2 major costs up front. The patients, they have other names for them, losses incurred, all that kind of stuff, but basically payment to patients and their defense cost. So those are the 2 things that only an actuary can really focus on. They can't tell you all the other cost elements that a malpractice carrier is going to add on top of that. But what they can say is, what is the impact of these elements in our system? So as an example, you have underwriting fees, administrative fees, dividends, the total cost of 26%. You have investment income. And for the last 6 years in Florida, the profit for medical malpractice carriers is 40%. Now, so that's a sidebar question, but one of the things I'm going to come back to, if you'll notice, there's 49% direct costs for the patient, payments, and defense costs. And then there's another, about 100% of that that's on top of that. It's about twice that much. That will come in handy here in a second. Just wanted you to remember, it's about twice that much of what is paid to patients. So let's go ahead and look at the actuarial. We basically wanted to do an impact summary for, first of all, let me make sure I didn't skip a slide. Okay. So here's in the current system. Here's how many claims are paid in Florida, 1,489. Under ours, it would be actuarially 3,382, which is more than double the amount. I know you're getting nervous. Their patient payments are $555 million in Florida. This is how much checks were written for patients directly. Under our system, it would be $810 million, an increase of $250 million. And I know your blood pressure is even getting more. But then we have defense cost of $229 in the current system. Under our system, I personally don't see how there's any defense cost. The actuary thinks that there'll be some, but there's really nothing a defense attorney or a plaintiff's attorney can do. They can't depose, they can't discover, they can't do anything. They could, make sure that the record is done right and the process is done right, but there's just limited amount of time and effort that they'll be in our system. But I'll let them put in the $77 million. And so, the total system cost, basically, under that, the cost of our system is $100 million more in the combination cost and total cost. Okay, so, but wait. Let's talk about the cost by provider class. First of all, I want to bring over the $887 million from the previous, that's the total cost of the system. Now, we have an administration fee right now that says it cannot be more than $500 per physician, $100 a bed at a hospital, et cetera, et cetera. It's in the bill. You can take a look at it. Our cost is not this much, but let's just assume that all that was charged at 100%. That's an additional cost to run patient compensation system to the system of $95 million. So it's close to $1 billion. But now let's take a look at where that is. Hospitals pay $471 million. You got nursing homes, 164, nursing 44, dentistry, and then other providers, allied health, and so forth. So physicians pay $247 million out of close to $1 billion, roughly about a fourth. And so that's the basis that all of you guys, all the physicians in Florida, would have to chalk up $250 million roughly for the system. So now let's actually figure out what that premium is. Now, our actuarial basis is this way. We we couldn't speak. I couldn't say that a malpractice carrier's premium should be something, okay? So what I did, I basically said, what if we only had a patient trust fund where physicians just paid in this system, one premium and they're done, zero deductible, unlimited coverage forever? What would the actuarial cost of that system be? And that's what this first actuarial number is. So we did it by specialty. We added up the full-time equivalent. There's 60,000 plus physician licenses, but by our studies, our actuarial studies, it's around 45,000, close to 46,000 that are actually working on a full-time basis. And so then we say, based on their historical awards, here's all the money in each one of these specialties. And this is a bunch of numbers, but I want you to look over to the right bottom. It's $247 million, just like we talked about on the previous page, okay? Then we said, okay, based under each one of those, what would be the premium paying to patient compensation system? You're not going to believe this, but I want you to think about it. So it's this $247 million. So basically, this is it. The highest premium for that $247 million is neurosurgery for $21,560. I know you don't believe me, but let's just think about something. We talked about the fact that patients are going to get $250 million more. It's almost $1 billion. It's more money. You're 250, divided by 50,000 doctors, you add it up. These are the numbers, whether, you know, I don't know how to defend it. I know it's an incredible number because I know what it costs in Florida. We probably have a couple hundred physicians that we insure in Florida ourselves, so we get it. But this is the numbers. Now, to come up with a premium for the carriers, would basically say, you remember a while ago I said, well, you know, it's 100% more than what it costs, right? Well, let's just play like it's 200% more. Let's play like the malpractice carrier says, well, we have some other expenses, whatever. Let's add 200. So basically, you multiply it times 3. So it's $64,000 for neurosurgery, unlimited coverage, zero deductible. And again, especially the people that live in this neck of the woods, that's still a significant decrease over an unlimited coverage policy that you can't even get right now in the state of Florida. You could not get an occurrence policy. This is an occurrence policy. Zero deductible, unlimited coverage. And that's the actual numbers of our system. Even though there's increased patients getting awards, over 100 and something percent, and even though there's 50% more money going to them, the total impact on an actual basis is what's before you. Now, so I wanted to talk about the physicians and that side. And the other benefits to the Florida taxpayers is it's, there's no taxes, current system pays for itself, reduction of cost of litigation in the courts in our current system, there wouldn't be that. We think that if doctors are right in Florida, that the state could save up to $2.2 billion of Medicaid, which is a real number, but pick any percent of that number you want to, then there's a potential opportunity there. And in fact, some people think Medicaid is even worse on defensive medicine because, real or not, there's a perception that they're the ones coming after the lottery, and so that's a prevailing thing. But even if they're like everybody else, there's that potential. The system benefits is it reduces overall health care costs as much as $2,000 a person in Florida. We're paying up to $2,000 a year per person for the privilege of having a dysfunctional tort system. Increases quality of care, and I think encourages adoption of medical innovation. So in summary, basically we think patient compensation system is a solution to replace the current tort system. We think it has a good legal precedence. It slashes defensive medicine costs. It increases access to justice. Now, I didn't stop. Let me talk to you why it's in our best interest for us to understand this access to justice issue. In every, first of all, because it's true, there's two reasons we want to do this. Number one, it's the right thing to do for patients. But number two, trial lawyers on every tort reform initiative you've ever had, they basically say, if you limit it to 250 or 500 or any limitation, you're denying access to justice. But nobody's ever put the current system on trial because it denies access to justice, because if you're poor, you don't have economic damages. Our polling suggests that trial lawyers will not, on average, take a case unless it's $600,000 of damages, not non-economic, just of damages, for them to take on a case that has 51% chance of winning. It's $600,000. So that means if you're a bus driver and you're out for 6 months of work or 2 years, you're never into the system. If you're unemployed, you're never into the system. If you're retired and don't have a job, you won't get an attorney to represent you. It's a complete illusory dream that people think they have a right to access to justice, a right to sue somebody, the right to get justice and so forth. They have right to have a settlement. The reason that we're using this is, A, it's true, B, it has bipartisan support, and it's the right thing to do. The people that don't have a job, that are poor, are the ones that need it more than other people, and so we just think it's a more fair system. Now, our actuarial study, I want to let you know, we know that out of the 1,900 claims that were paid last year, there's many claims that were settled for business reasons and that would not even be in our system. We think would just be gone. We took none out. With the actuarial, we basically said we know there's settlements for $50,000, $30,000, $100,000, and so forth. We just took that out and said we don't care. But so we really believe this is a very conservative amount. But we believe that our messaging needs to be focusing on this. We believe it improves patient safety to live in that environment, to be able to admit mistakes. And we think it's a more sane, efficient way to use funds, and more patients get more compensation, and there's no cost to taxpayers.